This is the Zoning Board of Adjustment for Madison, and can we all rise? And George, can you lead us in the Pledge of Allegiance? I think the flag will be good.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so while there are quite a few cases on the docket for tonight, because we only have 4 board members available who can vote, all of the applicants have requested in writing that we continue the cases to February. So we have to do that formally. Attorney Johnson has asked us to consider all of his cases as one request for continuation, which we did the last time. So I'll read those case numbers and the names that are associated with that. That's case 2312 for Andre and Erica Medeiros, case 2313 for Chad and Brittany Artizzoni, case 2314 for Ryan Finn and Grace Harrigan, case 2315 for Keith and Allison Kellerman, case 2316 for Monica Maria McMillan and Laura Thompson, case 2317 for Seamus O'Brien and Kayla Walsh O'Brien, case 2318 for Matthew Petty and Jennifer Swift, case 2319 for Brian Burns, case 2320 for Corey Jade and Cynthia Franklin, case 2322, we're skipping 2321 here.
It's already,
Because we did it, yeah, so just so you know, it's intentional, wasn't an oversight. 2322 for Kaylin Duchenis and Kaylin Couch. Case 2324 for David and Billy Keiselbach. And okay, those are the cases that are all represented by Attorney Matt Johnson, and I'd like to move that we continue those cases as requested by Mr. Johnson to the meeting at 6 o'clock in February. What's the date again?
21st.
21st, February 21st.
I'll second that.
Place, the place. I'm going to check availability here, so I'm going to put that in the motion.
Okay, so we intend to meet here.
Yeah.
But there's a contingency that we don't actually have it approved, so if you're planning to come to that meeting, please pay attention to the notice.
Pending availability, I'll put that in the motion, and it's posted on the website.
Yeah. Okay, so that's Doug seconded to that. All in favor of continuing these cases till February 21st, say aye.
Aye.
Aye. Okay. Okay, so now we have a request, just take these in case order. What'd you say, Sharon? What?
I guess I have,
Yeah.
somebody in the audience brought up a good question. Since Mark and myself are recused, we can or cannot vote.
No, but I'm counting, actually, we have 3 board members, and that's all that's required for
Got it.
continuation.
Yep.
Sharon voted as well, which is fine. We haven't formally, it's my job to raise you up. I can raise you up to a voting member, but 3 votes is all that's required to continue. Okay. Okay. So the next one is 2323 which is Henry P. Moscone, asking for a variance on a property, and he has asked, due to his absence from town, to continue this case until June. Yeah, what's the date in June, Kate?
Oh, hold on.
Just a second.
I'm not that far ahead. We are looking at the 19th.
One, two, three, yep, June 19th.
June 19th, okay.
Yep.
So Mr. Moscone has asked if we can continue that case till June 19th.
So moved.
At the Madison Town Hall.
To Madison, yes, Madison Town Hall, June 19th at 6 PM.
Perfect, thank you.
Doug has so moved. You want a second?
Second.
Okay. All in favor, say aye.
Aye.
Aye. Okay. Formally, Bill, you and Mark are alternates, so not voting members.
Okay,
Okay.
thank you.
But we do have four votes, Kate. Okay. So then we have case 2325
It's a new one, right?
is a new case, yes, not represented. It's also an appeal of an administrative decision from Rishi Saxena and Abhishek Sahai, and we have a request in writing from them. I'm going to enjoy the musical accompaniment to the decision here.
I've been told.
Anyway, they didn't mention a specific date, but they want to continue it to the next opportunity when they could have 5 board members present, so we will continue this case. I move we continue this case to February 21st, contingently here in this room at 6 o'clock. That's
Second.
case 2325.
I'll second it.
Okay, all in favor?
Aye.
Aye.
Okay, so we have 4 votes for that, so those cases are continued. Is that all the cases? Did I cover
Yes.
them all?
I think so.
Right.
Mr.
So-
Chair, may I ask a question?
Right. Okay, so the
As the-
cases are
I got a
covered.
question.
I have a
Yes.
question, a couple questions. One is, as we, at the last meeting, there were several cases that continued, and there was a discussion regarding status quo. That still holds true for the ones that are continued, correct?
If by status quo you mean whether the town has the right to fine them or whether they are in suspension, is that what you're talking about?
That was a question. I know Officer Boyd had brought it up with some of the letters that were written on a cease and desist.
Yeah, I don't remember the exact answer to that. The point is that since they're technically in process, they shouldn't be,
Shouldn't be conducting
they
any.
shouldn't be conducting any of the business which they were asked to cease and desist. However, the time that it takes for us is not counted toward the time limitations.
Okay.
Right? So in other words, if they had a year, that year doesn't expire because we continue it out. You know, that was set at the time of the application.
Okay.
Okay? However, there is risk associated with the fact if the case falls out against them, then the town has the option to enforce
To enforce it.
it, you know, in the time frame that was there. Okay? Does that answer the question?
Yes, it does. I mean, there's 2 new ones on here, and I know it was discussed at pretty good length the last meeting.
Yeah. Right, so if they continue doing business, yes, then they do that at their own risk. This board is not an enforcement agency, so we actually have nothing to do with that in any direct sense, other than the fact that our process has bearing on it. Okay, so, Kate, do we have anything else to do with the cases tonight?
No.
No, okay, so the board does have other business, you're all welcome to stay. But we're going to, approve our minutes, discuss a procedural change, and take a question from the audience.
Thank you. My name is Paul McKenna.
Yeah,
I'm a little concerned about something because this is the fourth time that this has been continued for the STRs, okay? And, you know, they've been granted 4 times. When is enough enough? Is there a mechanism in place to say, hey, you're abusing this? You know, it's, how does the board determine when to proceed? I mean, we've had people come from Florida to talk during the select board meeting on the SDR issues. It's an enormous inconvenience for people to, and there doesn't appear to be any, and correct me if I'm wrong, please, there doesn't appear to be any mechanism in place that can tell the public that there's continuances. And if I understand this correctly, there are procedures and laws within your bylaws, it may not be a bylaw, within your procedures, more or less, this lawyer has asked for continuance in writing. If I understand it correctly, this lawyer is supposed to come here and ask for it and then get your blessing or not get your blessing. I mean, this guy seems to be abusing the system and everybody else's time. Please answer my questions, I'd appreciate it.
Well, I can answer, answer directly. The question is that, yes, there are procedures and that's why we're doing this. A meeting is a dynamic process. This board is allowed to discuss this topic only at a public hearing, and therefore, any decision that's to be made of any kind is an open question until this meeting takes place. Those procedures are there. It has been and is the case that when an applicant requests a continuation, it's usually based on the fact that, well, the legal basis is they're entitled to due process. This board is a quasi-judicial, it's not a legislative board, it's a quasi-judicial board, and so they're entitled to due process. And that due process, one of those elements is that they are, by statute, allowed to request a 5-member board. And because of things like vacation and people who have to recuse themselves, we sometimes don't know in advance if there's a 5-member board. In this case, we knew we could not provide a 5-member board on the date fixed. They were all informed in writing, and they all responded in writing that they would all prefer to have the option, due process, to wait for a 5-member board. And so that's all part of the process. So that decision can't actually be made. I mean, Kate
Put it
can.
on the website?
Can it be put on the website? Well, the answer to the question is that we can't actually continue the case until the board, 3 members of the board meet and make that decision. So I don't know how much information is required to be put on the website. I suppose for the convenience of the public, you know, you could say, well, if we knew that was the case, could we do that? I don't know. Kate, what do you know? Do we do?
I mean, you have to decide at your meeting, how can I post that you've continued it?
Well,
Yeah, go ahead.
I hear Mr. McKenna's point, and I've been in a similar situation where I've shown up to meetings and in fact, then it's on the agenda, and then in fact, it's not heard, it's continued. I think further discussion between us could be had about when we get a request for continuance. I don't know how easy the website is to update to be able to say, case 2314, scheduled to be heard on such and such a date, it's on this agenda, has requested a continuance. That way the individuals could make the decision as to whether or not they're going to attend that meeting, knowing that a continuance request is pending. Again, as the chairman said, this board can't make the determination of that continuance as to whether or not to grant it until the continuance is heard during the proper meeting. But if there's, I don't know that it would do any good to put on the uploaded agenda or even on the website that a continuance has been requested, because there are times when we won't necessarily agree to a continuance.
Or know in advance.
Or know in advance, until the person gets here that night.
The other question, please, is the lawyer, isn't the lawyer supposed to come here
I don't
and
think
do
so.
it in public? Isn't that part of the procedure? I'm a novice to this.
No, we're allowed to respond. I mean, we're not hearing any items directly relevant to the case. So no, if he wishes to request a continuation, and we've informed him in writing, then that's perfectly okay. I mean, no one is actually ever required to be here.
Okay.
We don't subpoena people, so to speak.
No, I just thought it was
Right.
a procedure that if a lawyer or anybody wanted a continuance, they had to come here before the group, before the board, and ask for a continuance.
Here are the procedures right here. I'm looking for it. I can't find it.
I don't know that,
RSA 673.33.
Read it.
I don't have it typed out here.
Okay. RSA, what was it?
RSA 673, semicolon, 33.
And we don't have it.
training, zoning board of adjustment, building code of appeals,
Oops, on there.
Six, seven-
page 384.
380, page 384.
Okay. Sharon, you want to read it?
No, it's 30.
Or is it
Yeah,
extensive?
but I don't know that there is a 33.
Okay, which one was it again? 67333?
673, semicolon, 33.
Right, but we go from 673, oh, all the way to
Yeah, no, we're on the wrong page here.
32, 32B. 33 is on page 420, the bottom,
Yep.
bottom right-hand side of page 420. Is there a particular portion within that? Because it's several pages long.
Type it out. I may misunderstand it, so please correct me if I'm wrong.
Yeah, no fair substantial relationship.
Yeah, well, 33 is the longer, just for the record.
Hardship to
It's
zoning.
the power, it has to do with the powers of the zoning board of adjustment, and it's a relatively long section.
These are all the
I mean,
unnecessary hardship.
we could review it, but it has not been the practice of the board to require an in-person.
Thank you.
And I know that we're not allowed to subpoena people. What's,
Thank you for listening.
yes, no, well, that's what we're here for. The whole purpose of this board is to provide a safety relief valve, for the public in the event that any ordinance either is inappropriately applied, not applied, or, someone feels that that their unique situation is not covered, by the ordinance, so we hear that. That's what it's for. Okay. Okay, so unless there's any other comments in the public, then we will proceed with the reading of one procedural change. I believe this is the second reading of this public reading, right? Kate?
Kate, is this the second reading of this procedure? Sorry, I don't think she heard you, sorry.
Yeah, this is, I believe we have to read these things 3 times in public before they can be officially put into our records. But the procedural change that's mentioned here, I'll just read it out loud. It has to do with the timing of the meetings. We've mentioned it before. The proposed change is that regular meetings shall be held in the lower level meeting room of the Madison Town Hall at 6 p.m. on the third Wednesday of each month. No change there. when an applicant is to be heard. No new business will be opened after 9 PM, that's the change. No new business will be opened after 9 PM, and the meetings will conclude by 10 PM. Other meetings may be held at the call of the chairman, provided public notice, and notice to each member is given in accordance with RSA 91-A:2, subparagraph 2. Oh, no, this says in these minutes that that was the second reading of the rules of procedure, so this would be the third reading. So after tonight, this is official, assuming that we go back and find where it was the first. Didn't hear you.
Yeah, this is your second.
Third.
Well, this says, underneath that, this is the second reading of this. So we read it, so tonight,
One more, right? Three.
No, tonight would be the
Oh,
third.
three.
Third.
Okay,
Tonight's the
gotcha.
third.
yeah, no, what I meant was I'm reading from the
That's okay.
minutes, unless there's an error in the minutes. We have not approved these minutes yet, but if,
Told you, go to the
Right.
doctor.
okay. Okay, so we've read that 3 times, Kate, so assuming that the minutes are approved as written, then that goes into effect, goes into the record. Okay, the other item of business tonight is the approval of our minutes of the November 15th meeting. They are rather extensive. What we don't need to approve, of course, are the addendums, because those were submitted to us, right? So we recognize that we have, what did you call them? Exhibits that have been attached to the minutes. Those are the items which were presented by various members of the public or the applicants during the course of the meeting. Nevertheless, the minutes are still 23 pages long. Let me just ask a question. We got 2 options here. One is, have members of the board had a chance to feel that they have read these minutes well enough that you are confident? Do we have?
Yeah, I'm
Have
fine.
Okay, so do we have suggestions for amendments to the minutes
Like grammatical.
as a result of you having a chance to read through them?
Mr. Chairman, I just found some grammatical,
That's fine. A couple of grammatical things is fine. So
The substance of
are there substantial? No, the grammatical things we will correct as well, that's fine. But I want to know if there are any substantial changes to the minutes in terms of.
Not that I saw.
Okay, so let's go ahead and start, Mr. Dempster. If you have grammatical changes, that's fine.
yeah, if we can go to page 12 of 23. 12 of 23, first paragraph near the bottom, Kudrick versus Conway. If you read down the next sentence, code enforcement was given the green light to proceed and given the green light to proceed. So it was twice.
Yep.
Did you get that?
Yeah.
Page 13 of 23, last paragraph, second sentence. Attorney Bolt reviewed the letter and stated the references to the proper statute 676-17, which states the penalty 15. Is that is?
the penalty.
That can even be in there.
I think that was it. I thought I had one more that I found.
I'm sorry, what was the suggested change there?
Well, whether 15 is correct.
Take out 15. I think that's supposed to be is.
Oh,
No, so if we read it with the word is, I don't think it still makes sense.
No.
No, I think it's just, the number got in there for some reason, I don't know how.
Just cross the
I'm just
number out.
taking the number out.
But
Okay.
even if I take the number
Okay,
out,
so the
Penalty,
number
which is
doesn't need to
got
be
it.
there.
which is the enforcement, so he would treat it as a cease and desist.
Yeah, that's
Yeah.
fine.
I
okay.
don't know how 15 got in there.
So,
I'm going to put a comma after arms.
I think that was it, Mr. Chairman.
Sharon, did you have any?
No, I had the first one, I missed the second one.
Okay.
Good.
There,
Doug,
yeah.
George, you have anything? Mark, did you have anything?
No, I'm all set, thank you.
Okay. Okay, is the board comfortable approving the minutes, or does anybody feel that we need more time to go over these lengthy minutes?
I think we can move ahead.
Okay. Have a motion to approve the minutes as amended?
I move to approve the amendments as amended with the grammatical changes.
Second.
Second.
Okay, Sharon, second. All in favor?
Aye.
Aye.
Okay. Okay, so the minutes of November 15th are approved as amended. Kate, do we have anything else we have to discuss administratively tonight?
Well, I sent you, I know you were out of town. I sent you the 2022 annual report from last year
Right.
that we need to get done. And Linda really wants it as soon as possible, put it in, because we're getting ready to get the town reports ready, so.
Okay, so that's something I need to do.
I did email you last year, so you had something to go by.
Yeah, right, no,
But I
right.
knew you were out of town, so.
Yeah, okay, when does she want it?
Yes, perfect.
it was by-
What's the
by
official
next
deadline?
Week or so, if that
What-
would work, the 25th. So that would be next,
You could do the planning board one too, if you want.
oh, conservation too, if you want.
Okay,
Just teasing.
yes, I'll do that in the next
By
couple of days.
next week. I mean, that's a rough, first
I
rough
understand.
draft.
No, I
She just wants to
understand.
have something, I mean, if we have to doctor it up, you can, but
Nope, that's fine, no problem.
something,
I will make sure I do that.
Yeah,
yeah.
I mean, if you just read the minutes and sort of
Pretty.
synopsis.
Yeah. Have you worked yet?
I haven't done mine yet,
Oh,
but
okay, not yours. Tried to put them on to,
big thoughts.
Okay, board member have any other business for the evening? Yes.
I just have one question. And maybe Mark can answer this. Is planning board meeting, it was mentioned that there was going to be some definition changes or changes through a petition article on some zoning ordinances. And I don't know if anybody's seen those or.
I was going to say at the,
Okay.
Nope,
at
never was
the,
circulated.
We never got-
I heard the grapevine one was coming, but never happened.
at
Yeah.
the budget committee last night, we did ask Linda and the selectmen were there, whether they were in receipt of any other petition warrant articles, and they said, not yet, so.
Okay.
But they're not
Isn't
until
it-
the 5th.
But they're not due until January, or till February, the beginning of
Yeah.
February.
But
So people have time.
planning board stuff's too late.
Right.
Right, you guys were due in January, or the beginning of January, like
Yeah.
the 5th.
Yeah,
But
so the point is.
citizenry can still,
Yeah.
Right, so a citizen warrant can still come up till
Right, petition
February
warrant
5th.
article, right.
But at the moment, what you're saying, Mark, is that the planning board has no changes to the zoning ordinance.
No,
on the docket
and
from the
it's
planning-
too late for us to have sufficient public hearings
Yeah, right,
to,
right,
so.
right.
The only thing we have is we've changed 13B. No more 13B.
That is, you took 13B out.
Well, no more expansion of non-conforming use.
Was that voted on last year, or no? That's what you're,
We've been fighting with that for like 3 years.
so what you're saying is that on the ballot this year will be an elimination of 13B?
Of expansion of regulatory expansion of non-conforming use.
Meaning that there will be no expansion.
there will be no.
The only expansion would be if you came to this board and asked for it.
Yeah. Okay,
It'll be posted here. I have postings for it when we come down for voting. It'll be posted outside. I've already got it ready to go.
Question.
you have, oh,
Paul McKenna again. I
Yeah.
don't know if this is the right time to
You got to
ask
come to
this.
the microphone,
Sure.
please.
On the November 15th meeting, there was the issue 2310. It was for 10 Barton Place. The gentleman appealed, and if I understand it correctly, he didn't show up for his appeal at the lower library, I think it might have been. So I'm wondering, has this board sent a notification to the select board updating that case?
That's the Gage case.
The Gage case.
Right, we heard that
I
case.
think,
There was okay, just for the record, what happened was Mr. Gage was denied his original application at the November 17th meeting. He had 30 days to appeal. He made that appeal. And since the December meeting was canceled, since there was nothing on the agenda, we had to have a special meeting in order to answer his request for an appeal within 30 days. The board met and decided that there was not sufficient grounds for him to appeal to this board, which means if he so chooses, he can go to the Housing Board of Appeals or the Superior Court. Now, the official question you asked is whether the selectmen were informed. Well, I mean, I can assume they were because Kate and the selectman's secretary sit in the same office and talk to each other, but was there an official communication, or did the selectmen know?
I mean, she knows, yeah.
I
Yeah.
would like to request an official notice informing the select board that, if that's possible to do,
Well, if
in writing.
you want us to inform the select board that we,
Update whatever happened and what's going on with that case.
well, the minutes of those meetings are a part of the regular review of the, I mean, we took minutes of those meetings, that meeting,
I
right?
have minutes, yes.
I have a question. When do we approve those minutes? At the next meeting?
Yes, it'll be the
Okay,
next meeting.
not this meeting. Okay.
Okay. Well, once that is approved, would it be possible in writing to send it to the select board?
In writing, was email sufficient?
Fine.
Okay.
Well, I can do what I do with the conservation.
Can I ask why?
Why? Because in general, things have been moving so slowly with the select board. Okay? They originally told us that the 40 that they were going to do first, that they were gonna do it in an expedient way. Okay? It's gone 2.5 years, and they haven't even accomplished that. And from what they told us was, that was their plan, that's what they wanted to do, and now, things are getting backed up. I can personally tell you, as far as I know, and I'm going to give it to the select board next Tuesday, there are 11 more SDRs since they started with the 40 that we know about. The property beside me that had 2 police complaints and a letter from the chief stating he was gonna find that SDR. He just sold it 2 weeks ago. I went over and talked to the new owners. How are you? Welcome to Madison, blah, blah, blah. Are you gonna be an SDR? Oh, yes, I am. I'm a Realtor. I have a ton of properties in Rhode Island. Okay? So-
Not to interrupt you, but the reality
I
is
get carried
that that is an issue for the police and the
So
selectmen,
my point is,
not this board.
I would appreciate it if you would contact, once the minutes are approved, that you would, in writing, in email or whatever, make the select board aware of what's happened. Thank you.
Maybe we should make it routine to give the select board our notice of decisions.
Pending approval of the minutes, but these are the.
Yeah.
Well, the decision letter is usually done within 5 days.
Yes.
With
And
5
this-
days.
I was gonna say, the decision letter
And it
in
would
that
be
case is-
as
has
simple
no-
as Kate doing this.
Right,
Walking down the hall.
to give it
Yeah.
to.
I mean, that's not an unreasonable request that the selectmen are informed of our decisions
Yeah.
as they go. Let me just ask the question, since I don't work in the office, is that already a routine? No.
No, I do it with the conservation. I give the select, they made a a motion back, in the summer that they want the selectmen to see their minutes, so I put a stamp on it and they each sign it and I keep a log of them.
And then on the planning board, there's a selectman
On the rep.
on the board.
On the board, yeah. Well, I think frankly, given the nature of some of these minutes, if I were on a select board, I wouldn't read them, but no, I mean, I'm being a little facetious, but if they have the decision letters,
Yeah, here,
almost never do they take more than a page, and when they do, it's only like a page and a half.
Yeah.
That's not intimidating, and then they know what's going on.
Right.
So maybe we should just routinely copy the select board on the decision letters.
I can add them to the bottom where I add Bob Boyd and the file and all that stuff.
Yeah, let's just do that. That way,
oh, so
there's
you
no reason for
routinely
them
give it
not to know what
Boyd.
we've decided, right?
Boyd, the file, their
So
property
she,
tax file.
she gives it to Boyd
and
anyway.
I filed
so-
here.
Right. Well, yes, but Bob is directly involved in the administration of day-to-day things, where the selectmen are involved in the policy level decision, and I think that's Mr. McKenna's concern, is the policy level issues.
don't read that.
With the impact that, ongoing decisions has on that, so that's reasonable.
Supposed
Just-
to add them to the bottom when I do a
Yeah,
decision.
right.
No problem.
Anything else? Motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Aye. Okay, thank you, gentlemen.